All rise for the jury.
You may be seated. Would the foreperson please rise? I understand that you have a verdict.
That's correct, Your Honor.
Is it unanimous?
It's unanimous.
Please pass it to the bailiff. Would the defendant please rise? Verdict of the jury. We, the jury, unanimously find the defendant, Lincoln Pearson, guilty of the offense of sexual assault as charged in indictment, signed by the foreperson of the jury. Anything want to be taken up by either side?
Nothing from the state.
We would respectfully request to poll the jury.
Yes, sir. What I'm going to do now is ask each of you if the verdict I just read is your verdict. I'll start on the back left at the top, and we'll go across to each one of you. And I'll just call you by your number, not by your name. Juror number 1, is that your verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, is that your verdict?
Yes.
The front row on the left, juror number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes.
Juror number 10, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes.
And juror number 12, is that your verdict?
Yes.
All right. Thank you very much. I accept that verdict and will render that verdict at this time. The next thing that we will do is move into the punishment phase. But given the time today, we will not do that today. We will return tomorrow at 9 a.m. And at that time, the attorneys will have the opportunity to give you opening statements if they choose and to present evidence if they choose. After that is done, then we will again, I will give you the law, you will hear closing arguments, and then you will make your decision on the punishment in this case. Even though you have finished the guilt-innocent side, please remember my instructions. They remain in effect. You won't talk to anyone about this case. You won't talk, text, or tweet. You will not go to any locations. You will not look up anything about this case or any other case related to these legal issues. We do all of that because we want to protect the integrity of the process. Thank you so much for your time, for your deliberations today. We will see you back here tomorrow, ready to come into the courtroom at 9 a.m. Thank you. Deputy?
All rise for the jury.
You may be seated. Is there anything that needs to be taken up?
Judge, at this point, we would make a motion to increase bond and take the defendant into custody.
Defense, would you like to be heard?
I would, Your Honor. Judge, this defendant is probation eligible. We will be asking the jury for probation. He has attended every court setting on time without fail. He's been here. And we would respectfully request the opportunity to let him go home and come back as he has every other court setting tomorrow morning.
Based on the verdict of the jury and the gravity of the crime, we will take him into custody. Someone tell me what his bond is?
Judge, just for the record, I think I said increase, I meant revoke. Revoke.
You did request an increase. I was surprised by
Yes,
that.
yes, sorry, Judge.
Okay, we're gonna revoke bond. He will be taken into custody tonight. We will come back tomorrow. Let's make sure that he has the clothes that he needs so that he is in civilian clothes when we come back.
Yes.
All right? Anything else that needs to be taken up?
Judge, the state did run a criminal history on the defendant and found a May 2024 domestic violence arrest out of Maine, the state of Maine. We found that out yesterday. We finally got the offense report from the detective up there today. We gave it to the defense. We amended our notice of our witness list, as well as our 3707G notice. What 3707G says is that we need to let defense know about potential punishment evidence within a reasonable time. This would be hours before punishment begins. It is up to the court. There's no bright line rule about what a reasonable time is. We just wanted to let the court know that this is when we've done this, so that you can kind of make that determination now, so that we can either tell the witnesses that they need to come, or if you'll keep that evidence out, just so that we don't bring people here that we don't need to. And we wanted to let the defense have the opportunity to make argument as to the reasonableness of that now. Yes.
So you told me when you received the offense report,
Correct.
when did you receive the notice of the offense?
Yesterday. On Wednesday.
And
Well, and we gave notice yesterday on Wednesday. We had a investigator, not assigned to this court, run a criminal history. And this other investigator found the Portland, Maine, offense from May. And so we gave notice to the defense. So we only knew about it yesterday, and we told defense about the charge. We got the offense report today. We gave it to the defense. Again, we know that there's a possibility that this court could say, it's too close and we're not gonna let you go into it. We just wanted to bring it up now so that we don't bring witnesses here tomorrow, if you do believe that it's too close.
are you bringing witnesses on that charge
Correct.
from Maine?
The victim in that case is from Central Texas. It's a former girlfriend.
You want to be heard, defense?
I would, Your Honor. Respectfully, Your Honor, in light of the late disclosure, we were in the middle of trial. Our argument would be twofold, and that is we were not provided notice. And so our ability to effectively counter those allegations by bringing witnesses of our own from Maine, if needed, an arresting officer, any other witnesses, we haven't been provided any information about the offense other than what it was, where it is, the agency involved, other witnesses that could potentially be involved. So that lack of notice inhibits or prohibits our ability to zealously advocate for our client in refuting those claims. It's, Judge, also our argument respectfully would be with a reasonable amount of diligence that on the state's behalf, whoever is in charge of running those criminal histories, that could have been discovered months ago and wasn't for whatever reason. Again, I don't believe it's these prosecutors, but that could have been discovered with a reasonable amount of diligence. It sounds like it was just running a name through a criminal history database to uncover it.
Okay, I'm not going to make that decision right now.
Okay,
I want to look at some case law. If either one of you want to look into that and provide it earlier in the morning, if you want to either email it
Sure.
to our, to Ms. Linkart,
yes,
you can do that so that I can take a look at it. I mean, I'm hearing both arguments and understanding where we are. Understand the concerns of both of you.
yeah, and yeah, from the state's perspective, I think the case law says as long as it's provided before punishment starts and it's within a reasonable time, but it leaves reasonable up to the court, which is why we wanted to bring it to the court's attention now because we know that it is at the 11th hour. So we'll look at further case law and bring it up if necessary. We'll have witnesses here if we need to, and then you can make your determination then.
This doesn't apply.
Yeah, the breadth of what it allows.
All right.
I think I understand, Your Honor.
Okay,
Yeah.
I just want to get it right. So let's, if you find stuff and I'm gonna go look, I'm gonna go spend some time right now looking at it.
Okay.
All right, thank you.
Thank you, Your Honor.
Yep, y'all have a good night.
Yes, sir. Okay, thank you.